Hello, and thank you for downloading this podcast. My name is Karen Killalea. I'm a partner and head of the employment team at Maples and Calder, Ireland, the Maples Group's law firm in Dublin. As usual, some housekeeping to cover off. If you're listening in from your usual podcast app, you'll find any resource documents and speaker information in the description. If you've clicked on the media player link sent to you by email, you can find this information in the notes section. As always, the podcast contains a general overview of handling redundancies in Ireland. It does not constitute legal advice, and if you have a specific situation or question, please do seek tailored legal advice. And last but not least, don't forget to subscribe on Apple Podcasts, Spotify or Google Podcasts. So I'm again joined today by my colleague Ciara Longaigh, who's an associate on the employment team here at Maples. The theme of today's podcast, it's the second in our season of How to Handle, and it is how to handle the preparation for and the management of a redundancy process in Ireland. I have to apologise for the break between our first episode and this second episode several months later, but we have been extremely busy. But anyway, we are committed to the How to Handle series. So in this episode, we are going to walk through the following. So first of all, we're going to look at what constitutes a redundancy situation under Irish law and what are the key characteristics of a redundancy. Secondly, we're going to look at the differences between running a collective redundancy process and an individual process. Thirdly, we are going to look at what an employer's key obligations are to run a redundancy process. Fourthly, we're going to look at the risks. What happens if the processes are not handled correctly? What's the risk there for the employer in Ireland? And finally, we will talk you through some practical tips to consider if redundancies are confirmed after a consultation period. Okay, so let's just start with the basics before I hand over to Ciara to talk us through some of those matters. So I suppose we know that there are two key ingredients to a genuine redundancy process in Ireland, okay? And the first is that a redundancy must come about against a background of change in the business. So that change can be positive or negative. It's not necessarily the case that a business has to be doing poorly or struggling in order to effect redundancies. Change can also be positive. Secondly, a redundancy, as we know, relates to the role and not to the person. Okay, so change and impersonality are two key ingredients of any fair and authentic redundancy process in Ireland. So there's some very old WRC case law that tells us that those are the two cardinal principles of handling redundancies correctly in Ireland. And for anybody who wants to check the show notes, that case is St. Ledger versus Frontline Distributors Ireland. It's a 1995 case. And it's also clear from subsequent case law that the WRC will time and time again look at these key features in order to ensure that the decision to make a role redundant is not in fact a cloak, for example, for exiting perhaps an underperforming employee or employees who have engaged in misconduct or for any other reason other than a restructure. Another really helpful decision to look at, and I know, Ciara, you're going to talk about it a little bit later, is the decision of Panisi versus JVC Europe. Again, that's quite an old decision. It's a 2011 judgment, and it was a very clear, if you like, reiteration of the principle that redundancies just simply cannot be related to the employee personally. They relate to the role and not the employee. So, Ciara, I will hand over to you. Our legislation is old, dating back more than 50 years, but it does have a surprisingly broad definition of redundancy, which in fact works quite well even today, several decades later. So do you want to tell us what is a redundancy?
Yes, and as you say, the definition of redundancy provided in the legislation, it is still helpful today. It flows from the Redundancy Payments Act 1967 to 2014. I won't read out word for word, but the definition set out in section 7.2 sets out that a redundancy situation can arise in any of the following situations. So, for example, where an employer has or will cease to carry on business for the purposes for which the employee is employed, where the requirements of that business for an employee to carry out work of a particular kind in that place where they are employed have ceased or are diminished or are expected to cease or diminish, where the employer has decided to carry out business with fewer or no employees, may also arise where an employer has decided that the work for which the employee has been employed should be carried out in a different manner, for which the employee is not actually sufficiently qualified or trained. And then finally, a redundancy can also arise where an employer has decided that the work for which the employee has been employed to carry out, there are other employees who are also capable of doing that work, and the employee is not sufficiently trained or qualified to carry out that other work.
Yeah, exactly. Thanks, Ciara. So it's very clear from those five different limbs of the definition of redundancy that it's equally drafted, I suppose, or constructed to deal with businesses that are growing and moving and changing and innovating. So, look, moving on to the redundancy consultation process itself. So, a business may be in that sort of period of change. It's starting to look at the roles in the future organization that are needed, and it's starting to look at the roles that perhaps are not needed. So, an employer is going to have to assess pretty quickly whether they are going to meet the thresholds of a collective redundancy process before they actually start consultation with employees. And consultation is a very key step in the correct handling of redundancies. So, Ciara, let's talk about collective redundancies and collective consultation. Do you want to explain when that will arise?
Thanks, Karen. In order to determine if a collective redundancy consultation process will arise, an employer will need to consider the thresholds, as you mentioned, and those are set out in the Protection of Employment Act 1977. So an employer will be subject to the collective redundancy rules where within a 30-day period, 5 or more employees' roles are redundant, where there are between 21 and 49 employees normally employed by the employer. 10 or more roles are redundant, where there are between 50 and 99 employees normally employed, or 10% of or more roles are redundant, where there are between 100 and 299 employees normally employed, or finally 30 or more roles are redundant, where there are 300 or more employees normally employed.
Okay, thanks, Ciara. And it's definitely important to pay attention to employee numbers. Just make sure to look at the number of employees that have been employed by that employer on average over the past 12 months. Also, you need to just bear in mind that dismissals which occur by reason of the expiry of a fixed term contract are also counted towards the number of dismissals in any 30-day period. In other words, they cannot be disregarded. Okay, so let's press on. What happens? What's the significance of this? What happens if that threshold is met and an employer now has to run a collective redundancy process?
Well, if the threshold is met, the 1977 regulations provide that an employer must engage in an information and consultation process with the employee's representatives for at least 30 days and must also notify the Minister for Enterprise, Trade and Employment of the proposed collective redundancies. An employer is prohibited from issuing any notice of redundancy during the information and consultation process with the employee representatives. And these timelines are incredibly important. An employer cannot issue any notice of termination to employees until at least 30 days after the minister has been notified of the proposed collective redundancies have passed.
Yeah, thanks. And I know we'll talk about remedies a little bit later on, but just to bear in mind, there are individual statutory claims that can be brought. There also can be criminal liability imposed on the directors of the employer entity, and fines can also be imposed. So just really important to pay attention to the timelines when you are preparing your step plan or preparing for a collective redundancy process. Okay, so as I mentioned already, one of the key features of a correctly managed redundancy is consultation. So, proper, effective consultation with employee representatives is incredibly important. And there have been some very significant Irish and European cases over the years that has helped us to sort of refine and deepen our understanding of what that means. What is effective consultation? What is the content that you're bringing to employees? when should that take place? So we've had a very recent and significant High Court decision, which it's probably helpful to spend just a few moments maybe talking through this. And the recent High Court decision is the decision of Debenhams Retail Ireland Limited in liquidation and Jane Crow. So it's a decision that was published in 2025. Ciara, do you want to just talk us through the sort of learning points from this decision? It's in the show notes, by the way, but maybe talk us through it.
Yes, absolutely. And this was a very significant decision. Listeners will be all too familiar with the background to this case, in that in April 2020, Debenhams Ireland became insolvent after its UK parent company withdrew funding and a very large number of employees lost their jobs. So, as you mentioned, this case concerned an appeal by Debenhams, the entity that was in liquidation, against a Labour Court decision regarding collective redundancies. The key issues revolved around timing and the nature of the consultation process required under the 1977 Act and the originating EU directive, which the Irish obligations on collective redundancy flow from. The employees were claiming that the consultation process had not been commenced in good time or at the earliest opportunity, as is required by the directive and indeed the 1977 Act. The facts were that the board of directors of the Irish subsidiary met on the 9th of April 2020 to discuss the situation. Information about proposed redundancies was provided to the employee representatives on the 14th of April 2020, and following this, provisional liquidators were appointed on the 16th of April 2020, and the first consultation meeting was held with the employee representatives. So the WRC held that the redundancy consultation process was required to commence earlier than it did. It was noted that the consequence of commencing the process when the liquidators were appointed narrowed the options available to reduce the number of redundancies. And in addition, the WRC noted that when it did actually commence, the consultation process was not conducted in a meaningful way, as relevant information, which was necessary for the employees in question, was not supplied to them. It was therefore held that Debenhams had failed to meet the requirement to consult pursuant to Section 9 of the 1977 Act and the directive. On appeal to the Labour Court, it was decided that while Debenhams had engaged in consultation for 30 days prior to the notices of redundancy issuing, they had failed to hold meaningful consultations in good time, and that in waiting to start the consultation process until the liquidator had been appointed, the available options had narrowed significantly. It was noted that there was no requirement on the employer to have all relevant information available before commencing the consultation process, and the Labour Court found that the consultation process should have started on the 9th of April 2020, and the fact that it didn't commence until the 17th of April 2020 meant that Debenhams had not complied with the requirements of Section 9 of the 1977 Act. The appeal to the High Court was an appeal on a point of law. Debenhams submitted that the Labour Court was wrong as a matter of law in respect of a number of matters. Firstly, in holding that the obligation to commence consultations under Section 9 of the 1977 Act arose on the 9th of April 2020, that the Labour Court had erred in law in finding that the process only commenced with the holding of the first consultation meeting, that the Labour Court had also erred in law in finding that the available options had been lost in that delay of 8 days, and that there was no basis in law for awarding the compensation to the respondent employees. There are a number of key takeaway points from the judgment. As you mentioned, it was a very significant decision from earlier this year. Firstly, the High Court determined that Debenhams' obligation to begin the 30-day consultation process period arose on the 9th of April 2020, when the board first considered the prospect of collective redundancies. The High Court ruled that the consultation had actually begun on the 14th of April, when the required information was provided to the union representatives. Interestingly, this was actually 2 days before the first consultation meeting. And then finally, the High Court ruled that despite the 5-day delay between Debenhams' obligation arising and the consultation beginning, there was no evidence to support any loss of options as a result of the delay, and that there was simply no basis for the compensation awards that the Labour Court had awarded to the complainant.
Thanks very much, Ciara. Very nicely summarised. complicated situation, complicated case. Obviously, an awful lot of redundancies. A huge number of employees lost their jobs with the closure of Debenhams, and as a result of that very sort of lengthy legal process, the High Court has now, if you like, sort of clarified that whole thorny issue around consultation. You know, the proper timing and the content. That's in the show notes if anybody wants to take a look at that decision. Just shifting gears slightly, we've talked about employee representatives. Do you want to just explain, Ciara, what that means? Because we're talking about consultation being important and consultation being in the collective process, at least being conducted with the employee reps. So what's that?
Yeah, and I suppose during that process, an employer is obliged to consult with the employee representatives as opposed to the employees directly, and the representatives can be a trade union, as they were in the Debenhams decision. It can be a staff association or another body that the employer normally consults with. Otherwise, it can be the employees who are elected by a group of employees to act as the representative. And employee representatives will attend group consultation meetings as scheduled and will be provided with certain information in writing for distribution to the employees that they represent. The representatives should be afforded necessary time out of work for carrying out their representative functions. And furthermore, these representatives should not suffer any unfair treatment, such as, inclusion in the selection for redundancy because of their status or the activities that they're carrying out as representatives.
Yeah, absolutely. And that makes sense. Can you give us a couple of tips around the actual consultation, say frequency of meetings? This isn't particularly well described in any regulations anywhere. So do you want to just talk about that a little bit?
Yeah, the legislation is silent, as you say, in terms of how many meetings there should be during a 30-day consultation process. However, we would usually recommend weekly meetings where the employees or the employee representatives can be heard, their views considered, and information shared to facilitate a meaningful consultation process. During the consultation process, employers are, of course, obliged to explore, all possible alternatives to avoid the need to make employees' roles redundant. And this will require employers considering alternatives such as, suitable alternative employment within the business for employees, short-term layoffs, or even perhaps pay decreases or alternatives to avoid redundancy.
Okay, perfect. We spoke a little bit earlier about the avenues of redress, and obviously there are individual statutory claims that can be brought under the 1977 Act that you mentioned, and Ms. Crowe brought her claims under that Act. But what are the potential sanctions? I suppose that there are some quite significant fines and penalties. Do you want to just, I suppose, briefly summarize the potential sanctions for employers who don't adhere to the obligations that you mentioned in relation to consultation?
Yes, absolutely. An important topic, as you mentioned, the potential penalties are quite high in terms of monetary value. So, an employer who issues a notice of termination to an employee before the expiry of 30 days after the date on which the minister has been notified is liable to a fine not exceeding €250,000. And there are a number of additional penalties which can result. So, for example, if an employer actually fails to notify the minister of a proposed redundancy, there is a fine of up to €5,000. If an employer fails to consult with and inform the employees, there is also a potential fine of up to €5,000. And then finally, it is also worth noting that where an employer fails to keep records in accordance with the legislation, again, there is another penalty, and the maximum award is €5,000 under that section as well. So very significant fines.
Yeah, absolutely. Okay, thanks for that. All right, what we might do is shift gears again. And this time, shall we talk about individual redundancy process? So I think it's fair to say they are probably a lot more common, the individual redundancy processes. And what we mean by that is a non-collective process. So you've talked about the thresholds and the employee numbers and the number of dismissals that are effected within a 30-day period. So we're shifting gears away from that, and we're talking now about individual processes. So where you have a smaller number of roles that are being potentially eliminated or restructured. So I think it's fair to say, as a general principle, that we would not typically recommend that you would drop below a 3 to 4 week consultation period in any event. And many employers will observe that and respect that. And they understand that obviously communicating the risk of a redundancy to an employee it's a very difficult message to receive. And so in practice, many employers will, in any event, apply a sort of 3 to 4 week consultation period, even though they're not strictly speaking required to do so. And I think the case law will tell us that an employer needs to act reasonably and prepare reasonably to implement redundancies. And running a consultation process which stretches from sort of 3 to 4 weeks gives enough time and reasonable time to properly discuss that with the the potentially impacted employee and to explain all of that. So what we might do is maybe talk a little bit about the reasons for roles being placed at risk of redundancy, Ciara. So do you want to just talk a little bit about that in practice, about an employer's obligations, really in just making sure that they are using the correct route and using redundancy correctly?
Yes, absolutely. And when deciding whether an employee should be placed at risk of redundancy or not, it's important that an employer is able to evidence that there is a genuine business case for the redundancy. So employers should ensure that there is a genuine need to make the employee's role redundant from a business organizational perspective. Employers should be careful not to put themselves in a position where an employee could successfully argue that a redundancy situation has been orchestrated in order to remove them from the workforce under the pretense of redundancy. And not doing so could result in what is often referred to as a sham redundancy. It's worth mentioning the decision, the Panisi decision, which we mentioned a little bit earlier, a decision from the Irish High Court in 2011. This case highlighted that both impersonality and change are requirements for a genuine redundancy. So change can mean a reduction in the workforce, and employer is of course entitled to reorganize and to reduce employee numbers for legitimate business reasons. And then impersonality means that the redundancy should not concern factors which are subjective to the person being dismissed, or in other words, the redundancy is not a personal choice. There is also an additional case, which again we will include in the show notes, a WRC decision from April 2024, Stephen Hanley decision, which provides a stark warning for employers who make employees redundant where there is an absence of a genuine business case for doing so. In this case, the WRC awarded €46,000, the equivalent of 1 year's salary, to a complainant who was successfully argued that their redundancy was in fact a sham redundancy engineered by the shareholders of the respondent employer.
Yeah, perfect. That was really quite a high award in the circumstances. And really just to recap, I suppose, the learning points from the case law, and equally this applies to collective redundancy, but probably more important in the context of individual redundancies, because that is a more common, if you like, path that is used by employers. So I suppose three things. One, it is very helpful for an employer to map out what are the future roles that we need in the organization and what do they look like? And what are the roles that we are unlikely to need going forward? So that helps to really focus on the authenticity of the roles as opposed to the people being scrutinized in preparation for a redundancy exercise. Secondly, I suppose a good practical tip is to try to identify at an early stage whether you're going to have to select from a pool of employees. And in other words, if you have a number of employees, for example, in a team, and you're reducing the numbers in that team, in that situation, it is very likely that you're going to have to use selection criteria. So you just need to make sure as an employer in Ireland that the selection criteria is objective and that it is fairly applied to the employees within the pool. The third point, I think we'd reiterate at risk of repeating ourselves too much, is just to remind listeners that a meaningful consultation process that genuinely explores the possibility of avoiding the need for redundancies is conducted. So successful complainants, they can bring complaints under the unfair dismissals acts in relation to a dismissal which they say is unfair, and they can recover up to 2 years remuneration if they are found to have been unfairly dismissed. That is limited to financial loss. And equally, employees do have an obligation to mitigate their loss. But nonetheless, it is a very significant scale of compensation which is potentially available where a redundancy is not handled correctly and fairly. Ciara, do you want to talk us through another case which is worth highlighting for listeners?
Yes, absolutely. The WRC decision from last year, the Gráinne Sherlock versus Pluralsight Ireland decision, is particularly noteworthy on this point. In this case, the complainant was employed by the respondent for just under 4 years before she was dismissed following a redundancy consultation process, which the respondent employer maintained was legitimate due to economic challenges necessitating a reduction in workforce. The complainant argued that her selection for redundancy was unfair and manipulated to ensure her dismissal. In particular, the complainant employee highlighted issues such as a lack of transparency in the selection criteria, biased decision making, and inadequate consultation. The complainant also claimed that there was no real effort to find alternatives to redundancy during the consultation process. The WRC found that whilst there was a genuine redundancy situation, the selection criteria and the process were not objectively justified or fairly applied. The WRC noted that there was a lack of transparency, as the employee had alleged, and that the consultation process was deemed inadequate as it had not genuinely considered alternatives to redundancy or revisited the selection criteria. The complainant was awarded compensation of €112,000, which was calculated based on the complainant's financial loss, including base salary, on-target earnings, cash equity payments, and a performance bonus award, which she had not received as a result of her dismissal. This award was the equivalent of approximately 7 months of the complainant's annual remuneration in the position she had held before she was made redundant.
Okay, thanks. Yeah, that was a very high amount indeed. And we will also have a copy of that case in the show notes. Again, really important principle there, which is not only do you have to have an authentic redundancy situation, but you need to handle that redundancy situation procedurally in a fair manner. So I suppose that both the substance and the process are equally important from an Irish employment law perspective. Okay, a common question we get is, what are the statutory severance or redundancy entitlements in Ireland? Do you want to give us a short recap on those?
Yeah, absolutely. So I suppose the first point to note is that employees who have been employed for at least 2 years with the employer are entitled to a statutory redundancy payment under the Redundancy Payments Act. So employees who have not yet reached the 2-year mark will not be entitled to a statutory redundancy payment. And the figure is calculated at a rate of 2 weeks normal pay per year of service, with each week being capped at €600 per week, plus an additional week of salary. Also important for employers to note that the statutory redundancy payments will be paid tax-free, and the Irish government have provided a statutory redundancy calculator online, which is quite helpful in terms of assisting with these calculations. We will also provide a link to this calculator in the show notes in case helpful for listeners.
Yeah, that's very helpful. I know that calculator disappeared for a while, but it's obviously back. So we'll strike while the iron is hot, and we'll include the link in our show notes along with the cases that we have mentioned. Okay, well, look, I'm conscious we always try to do this in about 15-20 minutes, and we invariably run over time. So I am going to bring it to a close now. So Ciara, thanks very much once again for helping to put together this podcast. We hope listeners found this information useful. So thank you again for listening to the Maples Group Employment Law podcast. And if you have any questions or queries on any of the matters covered today or on employment legal issues in general in Ireland, please do get in touch with us. Thank you very much for feedback. We've received some really nice feedback from listeners, and we love to get that. So thanks for listening and subscribing, and we will be back again with another in our series of How to Handle. Thanks.